Welcome to the deep dive. Today we are tackling four really fundamental crimes against the person: assault, battery, mayhem, and stalking. They sound distinct, but wow, can they get confusing?
They absolutely can, especially because they often hinge on very technical distinctions, particularly the offender's mental state.
Exactly. So our mission today is to really cut through the legal jargon. We want to give you a solid element by element framework so you can analyze these correctly. Tell the difference between a threat and an actual touch, legally speaking.
That's the plan. We need to separate the actus rea, the actual conduct, from the mental state for each. So we'll map it out. Start with battery versus assault. Then look at the more serious injury crimes, mayhem and aggravated battery. And we'll finish up with modern stalking laws.
Perfect. Let's dive in. All right, let's start with the one most people think they know: criminal battery. What's the basic definition, the black letter rule, and what's the absolute key element that sets it apart from assault right away?
Okay, the general rule. Criminal battery is the unlawful application of force to another person.
Yeah.
And the non-negotiable element you mentioned, it's the result. Battery needs actual contact, some kind of resulting harm.
Contact. Okay,
Yeah.
so break that down. What are the core elements we need to prove?
Right, there are basically three. First, the defendant's conduct that could be an act, or sometimes even an omission, a failure to act. Second, the required mental state. This varies a bit. It could be specific intent to injure or criminal negligence, or even just doing some other unlawful act that results in the touching.
And third.
Third is the harmful result to the victim. And this is key. It means either actual bodily injury or just an offensive touching.
Okay, that result element, harmful result. Most people probably picture, bruises, a black eye. Does it have to be a visible injury? Or can merely touching someone be enough for battery?
Under the traditional view, the common law view, absolutely. Mere offensive touchings are enough.
Like what? Give me an example.
Spitting on someone, an unwanted kiss, grabbing someone's arm against their will. Things that might not cause physical pain, but are, offensive. Now, I should mention, modern statutes, especially ones influenced by the Model Penal Code, sometimes narrow that. They might limit battery to actual physical injury.
And leave offensive touching for, say, harassment charges.
Exactly. But the traditional rule is broader.
Okay, let's really test that traditional rule, the least touching idea. We need to look at People v. Shockley. And also, in ReTD, these cases seem to ask, does the force have to be, like, skin-on-skin contact? First, what are the legally dispositive facts?
Well, the essence reaffirmed in Shockley is that force against the person is sufficient. It doesn't need to be violent, doesn't need to cause pain or leave a mark, just unlawful force. In RePD involved contaminating a drink, which wasn't direct skin contact.
And what was the core legal issue the courts were grappling with in these situations?
The precise legal question was whether common law battery requires observable bodily injury, or if indirect force, or force applied to something connected to the person, the least touching, is enough.
What rule of law did the courts apply? Can you state the full rule and break down its elements regarding how force can be applied?
Okay, the rule is that the force doesn't have to be applied directly. Indirect application counts. So the elements for the application of force part are: 1, an unlawful act or omission; 2, the application of force itself; and 3, that force results in contact either with the person's body or with something intimately connected to the person.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the concept of indirect force, that first element, really in cases where there wasn't direct touching, like the examples in Shockley?
Right, so the sub-issue is whether indirect force counts. The sub-rule is, yes, the law isn't limited to direct contact. The court looked at examples like whipping a horse someone is riding, causing them to fall, or driving your car into the victim's car, or even, like in the Beausoleil case, forcing the victim to touch the defendant. The court's analysis applied this rule. The defendant's unlawful action set a force in motion, and that force resulted in contact with the victim, even indirectly. So conclusion, that element was met.
Understood. Now, what about the second element in application, the idea of force applied to something intimately connected to the victim? Let's use the facts from NRPT, the juvenile, putting urinal water in the soda. How did that fit the rule?
Okay, so the sub-issue here is what counts as intimately connected. The sub-rule the court used is that the force element is met if the defendant causes unwanted contact with something, well, intimately connected to the victim's body at that time. Applying that, the soda was in the victim's cup, and the victim drank it. It was entering their body. The court concluded that contaminating that drink was an unlawful application of force because the soda was intimately connected to the person at that moment. So yes, that element was met too.
And after analyzing all the elements, what was the court's final conclusion on the scope of force in battery?
The ultimate holding was clear. Battery covers both direct and indirect force. It includes contact with objects intimately connected to the victim. It strongly reaffirmed the broad scope of that touching element. You don't need violence, just unlawful contact.
So that least touching rule really does have teeth. It's much broader than many people think.
Okay, let's move to assault. This is where the real confusion often starts, I think, because assault can feel like half a crime. It's about the threat, maybe, or the attempt, not necessarily the completed act. What are the two main ways assault can happen in most places?
You're right, it's confusing because assault essentially exists in two different forms, sometimes even in the same jurisdiction. First, there's attempted battery assault. Second, there's intentional frightening or intentional scaring. Two distinct paths.
Okay, let's tackle attempted battery assault first. You said it requires a specific intent to injure, but this is where we hit that big split between states about presentability, right? What is that exactly, and why is it such a sticking point?
Presentability. It means the defendant had to be actually capable, objectively capable, of completing the battery right then and there.
So if I swing at you but you're 10 feet away? Exactly. Or the classic example. If the defendant points a gun they think is loaded, but it's actually empty, some states say, well, if the gun was unloaded, they didn't have the present ability to cause harm, so no attempted battery assault, even if they fully intended to shoot.
Even with the intent.
Even with the specific intent. But other states say, forget objective ability. If they intended to injure and took a clear step, an overt act, that's enough for the attempt. It's a major split.
We definitely need to analyze that. Let's use People v. Silva. The facts seem straightforward. Defendant aims a gun, tries to fire, believes it's loaded, but oops, it's unloaded.
Right. A aimed an unloaded gun at B, believing it was loaded, intending to shoot.
And what was the core legal issue for the court?
The legal question was whether assault, under that specific state's statute, which defined it as attempted battery, required actual objective present ability to commit the battery.
What rule of law did the court apply? Please state the rule and its elements.
The court looked at their statute, and it was strict. It explicitly required both an attempt to commit a battery and a present ability to do so. So the elements were, 1, an attempted physical application of force, 2, the specific intent to injure, and 3, crucially, present ability to injure.
Okay, thank you. Now for the court's elemental analysis. Let's focus on that tricky third element, present ability to injure. How did the court apply that element?
Right, so the sub-issue is, does aiming an unloaded gun meet presentability? The sub-rule, based on that statute, required objective capability. The court applied the facts, the gun was unloaded, therefore, objectively, the defendant lacked the physical mean, the presentability, to inflict the intended injury at that moment. So the court concluded that this third element was not met.
Even though the first two elements, attempt and intent, were clearly there.
Correct. The lack of objective presentability was fatal to the assault charge under that specific law.
And after analyzing all the elements, what was the court's final conclusion?
The holding was no assault conviction. The defendant walked on the assault charge because, regardless of his intent, the lack of present ability meant he couldn't satisfy all the elements required by that particular statute.
Wow. That really shows how much depends on the exact wording of the law in that state. It puts the focus squarely on objective reality, not just what was in the defendant's head. Okay, let's pivot to the other kind of assault, intentional scaring. You said presentability usually doesn't matter here. What elements define this type?
Right. For intentional scaring or intentional frightening, presentability is generally irrelevant. What matters is the victim's mind. The elements are, 1, the defendant acts with the intent to cause apprehension, that's fear of immediate, harmful, or offensive contact, not necessarily intent to actually injure. 2, the defendant's conduct has to be the kind that would arouse reasonable apprehension in the victim. A mere mean look or just words usually aren't enough. It needs to be more threatening.
Needs some kind of conduct.
Yes. And 3, the result must be actual mental apprehension in the victim. They have to actually feel afraid, and that fear has to be reasonable.
Okay, to really cement these differences, especially the intent part, can you walk us through that visceral hypothetical, the one about the blind man near the cliff edge? How does the defendant's intent change the potential crime?
Okay, great example. Imagine a blind man walking towards a cliff. Scenario 1. You have a duty to warn him, maybe you're his guide, but you fail to, and he falls and gets hurt. That could be criminal negligence battery by omission. Your failure to act caused the harm.
Okay. Negligence leading to battery.
Scenario 2. You intend to hurt him, you give him a little push towards the edge hoping he'll fall, but he catches his balance just in time. That's attempted battery assault. You had the specific intent to injure and took an overt act.
Makes sense. Intent to injure, failed attempt.
Scenario 3. Your only goal is to scare him. You yell, "Watch out, you're about to step off the cliff." Even though maybe he's not that close, he panics, he's terrified. You only intended to frighten him, and you succeeded. That's intentional frightening assault. See? Same situation, different crime, based entirely on the mental state. Negligence, intent to injure, or intent to cause fear.
Let's shift gears to crimes involving really severe injuries, starting with mayhem. That word itself sounds, well, medieval. What was its original point, and how do modern laws view mayhem?
It definitely has ancient roots. Historically, mayhem was about crippling injuries that made a man less able to fight for the king. Losing an eye, a hand, something that affected military service.
It was about combat readiness.
Pretty much. Modern statutes, they've completely ditched the military reason. Now, mayhem focuses on the permanence and severity of the injury itself, preserving the integrity of the human body. It usually requires one of three results. 1, permanent dismemberment, like cutting off a limb. 2, permanent disablement, like blinding someone or destroying an organ's function. Or 3, permanent disfigurement, like cutting off an ear or nose, something that permanently alters appearance.
Given how serious those outcomes are, what's the required mental state? Is being reckless enough if someone gets disfigured, or do you need more?
Almost always, mayhem requires a specific intent to maim, disable, or disfigure. Recklessness or negligence, even if it results in one of those terrible injuries, usually isn't enough for mayhem itself. It demands that focused, malicious intent to cause that specific kind of permanent harm.
Okay, specific intent is key for mayhem. Now, mayhem often falls under the broader category of aggravated battery. And a common way battery gets aggravated is using a deadly weapon. What counts as a deadly weapon? It's not just guns and knives, is it?
Oh, far from it. The definition is incredibly broad. A deadly weapon isn't defined by what it is, but by how it's used. It's basically anything animate or inanimate, used in a manner that's calculated or likely to produce death or serious bodily injury.
Anything. Like, give me some examples.
Sure. Rocks, cars, even teeth, if used to bite viciously or transmit disease. And yes, even stationary objects, things that don't move.
Stationary objects. That's wild. We have to look at Commonwealth v. Sexton. The facts, as I recall, involved the defendant slamming the victim's head or body onto concrete pavement, causing serious injury.
That sounds right. Forcefully using the environment against the victim.
And the core legal issue was pretty stark. Could that concrete pavement, something fixed and immovable, actually qualify as a dangerous weapon for aggravated battery?
Exactly. That was the question. Can part of the ground be a weapon?
So what rule of law did the court use to decide this? What are the elements of a dangerous weapon?
The rule they applied is that a dangerous weapon is any instrument which, under the specific circumstances of its use, has the capacity to inflict death or serious bodily harm. So the elements are, 1, it has to be an object or instrumentality. 2, it has to be used in a certain manner. And 3, that manner of use must make it capable of causing death or serious bodily injury.
Okay. Now, for the court's elemental analysis, let's focus on that first element. The object needing to be an object or instrumentality. How did the court say concrete pavement qualifies as an instrumentality when it's just sitting there, it's stationary?
Right. So
Yeah.
the sub-issue, can a stationary thing be an instrumentality? The sub-rule the court articulated was, yes, an object's stationary character does not prevent its use as a dangerous weapon. The court analyzed how the pavement was used. The defendant didn't wield the pavement itself, but they wielded the victim's body against the pavement. The pavement became the instrument of harm through the defendant's violent action of slamming victim onto it.
Yeah.
So the court concluded, yes, it can function as an instrumentality in this context. Element 1 met.
So the use makes it the weapon. It's not about carrying it.
Exactly. It's the manner of use, element 2, and the capability of harm, element 3, which were also clearly met by slamming someone onto concrete.
And therefore, what was the court's final conclusion?
The holding was that the concrete pavement, used in that violent manner against the victim, did qualify as a dangerous weapon. This affirmed the conviction for aggravated battery. It really underscores how broadly weapon can be interpreted based on usage.
All right, let's wrap up our legal breakdown with stalking. This one feels different. It's a relatively modern crime created by statute, really targeting a specific pattern of behavior that older laws maybe didn't capture well. What are the essential elements that define stalking today?
You're right, it's statutory and aims at patterns. The core elements usually are: 1. A coercive conduct. This is crucial. It means two or more separate acts that show a continuity of purpose, not just one isolated incident.
Okay, a pattern. Two or more acts. What else?
2. It has to be directed at a specific person. 3. There's a mental state requirement. This can vary, but often it's either the purpose to harass or cause distress, or are simply knowledge that the conducts would likely cause fear or distress.
So intent isn't always required. Knowledge might be enough.
In many statutes, yes. And fourth, the result. The conduct must cause reasonable fear or emotional distress in the victim.
Let's focus on that course of conduct element. Two or more acts. What kind of behavior is this really designed to catch? It sounds broad.
It is intentionally broad. It's meant to capture a pattern of behavior like repeatedly following someone, monitoring them, making unwanted communications calls, texts, emails, making threats, showing up places uninvited. It can even include contacting or spreading information about the victim through third parties, like in the Rux case implications.
And crucially, this covers online behavior too, right? Cyberstalking.
Absolutely. The definition of course of conduct and communication is usually written broadly enough to encompass electronic means, following someone digitally, harassing them online that fits the pattern.
Yeah. Okay, now the fear element. You mentioned reasonable fear. Courts often look at two things here, don't they? Subjective fear and objective fear. Which one is usually required to make sure these laws aren't too vague?
That's a critical point for constitutionality. Statutes often require both. First, subjective fear. Did this particular victim actually feel afraid or distressed? But second, and often more importantly for legal challenges, objective fear. Would a reasonable person in the victim's situation also feel fear or distress because of the defendant's conduct?
Why the objective standard?
Requiring that objective, reasonable person standard helps protect the law from being struck down as unconstitutionally vague. It avoids punishing conduct that might just annoy or alarm a uniquely sensitive person, but wouldn't reasonably scare others. It grounds the fear element in a community standard.
That makes sense. It feels like the whole point of stalking laws is quite different from assault. Assault is often about immediate fear, right? But stalking seems aimed at the psychological harm from a sustained threat of future harm.
Precisely. It recognizes the severe emotional toll that a pattern of harassment and threatening behavior can take, even if no physical violence has occurred yet or is immediately imminent. It's about the terror of what might happen because of this ongoing conduct.
Okay, wow. We've covered a ton of detailed law battery, the two types of assault, mayhem, aggravated battery, stalking, lots of elements, mental states, jurisdictional splits. Let's synthesize this. For someone listening, maybe facing an exam question or just trying to analyze a real-world scenario, can you give us a step-by-step diagnostic checklist? How do we spot the issues and structure the analysis using everything we've discussed?
Absolutely. Let's build that actionable checklist. When you see facts involving harm or threats, run through these 4 steps systematically. Step 1. Did contact occur? If yes, think battery. Apply the 3 elements. Conduct, mental state, harmful result. Immediately ask, was the force direct or was it indirect? Remember Shockley poisoning, hitting a car? Or was it just offensive touching, like in Repeaty's contaminated drink? Then nail down the mental state. Was it intent to injure, criminal negligence, or just an unlawful act resulting in contact?
Okay, start with contact for battery. What if there's no contact?
Step 2. Was contact attempted or apprehended? If no battery, check assault. Now you must distinguish the 2 types immediately. First, check attempted battery assault. Did the defendant have a specific intent to injure? Critically check the jurisdiction's rule on presentability. Is this a Silva state where an unloaded gun means no assault, or does intent plus an act suffice?
Got it. Check intent to injure and the presentability rule. What's the other assault type?
Second, check intentional frightening assault. Did the defendant act with the intent to cause apprehension? Fear. Was the conduct enough to cause reasonable apprehension in the victim? Remember, words alone usually aren't enough. And did the victim actually feel afraid? Presentability is usually irrelevant here.
Okay, so after checking battery and both types of assault, what's next if there was serious injury?
Step 3. Was the injury severe and permanent? Think mayhem or aggravated battery. If the facts describe a really serious injury, disfigurement, disablement, immediately check mayhem. Key element. Did the defendant have the specific intent to maim, disable, or disfigure? Recklessness isn't enough.
Specific intent for mayhem. What else?
Also check aggravated battery. Was
Oh.
a deadly weapon used? Remember how broad that is. Could it be a stationary object like the pavement in Sexton? Or even teeth? Also, was the victim in a protected class like police, elderly child? That can aggravate the battery too.
Right. Check weapon use broadly and victim status. Final step.
Step 4. Was there a pattern of harassing conduct? Think stalking. If the facts describe a series of acts over time directed at one person, check stalking. Did the facts establish a course of conduct, two or more related acts? Verify the defendant's mental state. Did they have the purpose to harass, or at least knowledge their actions would cause fear? And finally, did it result in reasonable fear or emotional distress for the victim?
That's a fantastic roadmap. Start with contact, move to attempts threats, check severity and weapons, and then look for patterns. It really forces you to analyze each element precisely.
That's the goal. Precision is absolutely everything when dealing with these crimes against the person. You have to isolate the conduct, the mental state, and the result for each potential crime.
Couldn't agree more. Well, as a final thought for our listeners to mull over, we've seen how these laws evolve, especially with stalking and cyberstalking being created to address new forms of harm. So, what's the deeper policy implication of basing criminal intent, particularly in stalking, not necessarily on whether the offender actually intends to follow through on a threat, but maybe just on their knowledge that their actions are likely to cause a reasonable person to feel distressed or afraid?
That's a profound question.
It really raises this ongoing tension, doesn't it? Balancing someone's freedom to move or speak against the need to protect potential victims from the very real psychological harm caused by credible, sustained threats, even if the perpetrator's ultimate plan is unclear.
A fascinating tension indeed. One that the law, I think, will continue to grapple with, especially as technology keeps changing how people interact and, unfortunately, how they can harass one another.
Thank you so much for guiding us through this incredibly detailed and really rigorous deep dive today.
My pleasure. These distinctions are vital to understand.